Start, Pyara. The petitioners herein by these two petitions challenging the constitutional validity of sections 22 and 23 of the Income Tax Act 1961 and the legality of the notices dated 29th March 1972 issued by respondent number 1 herein under section 148 of the said act for reopening the assessment for assessment years 1967-68 and 1968-69, as he had reason to believe that income of the petitioner chargeable to tax for the said years had escaped assessment within the meaning of section 147 of the said act. In order to appreciate the rival contentions in proper perspective, a few facts need to be stated. Petitioner number 1 is the son and petitioners numbers 2 and 3 are grandson of one Balabhai, who died on 31st December 1957 in jointness with his son, petitioner number 1, and two grandson, petitioner numbers 2 and 3, and other great grandsons. The deceased Balabhai had separate properties as well as joint family properties. The deceased had executed a will dated 6th October 1956, bequeathing his undivided one-half share in the joint family properties, which consisted of partnership business, share, securities, and immovable properties, as well as individual properties, to his grandsons, petitioners numbers 2 and 3, herein, though no executor was appointed for carrying out the directions in the said will, petitioner number 1 administered the properties bequeathed under the will as executor and legal representative of the late Balabhai, petitioner number 1, on the death of his father. The said Balabhai also received his half share in the joint family property, he being a co-parcener, and he therefore qua his half share constituted along with his two sons, petitioner numbers 2 and 3, and their sons, a similar Hindu undivided family of which he was the karta. In these two petitions, we are concerned only with the half share of the late Balabhai in joint family properties which he bequeathed by will. No petitioner numbers 2 and as well as with the half share in the same which petitioner number 1 received as co-parcener. After the death of Balabhai, the income from the estate of the deceased, which was bequeathed to petitioners numbers 2 and 3 under the aforesaid will, was assessed in the hands of petitioner number 1 as a legal representative of late Balabhai. The income from the remaining half share which belonged to petitioner number 1 was assessed in his hand at Sakarlal Balabhai. The joint family properties included inter alia 2 plots of land bearing final plot numbers 560 and 583 of Ellis Bridge Town Planning Scheme number 3, with buildings standing thereon situated in Ellis Bridge, Ahmedabad. Both the buildings and the open plots of land appurtenant thereto were self-occupied by the petitioners and their families. It is the case of the petitioner number 1 as legal representative of late Balabhai. The letting value of the immovable property up to the assessment year 1961-62 was taken as the same as per the municipal valuation by the predecessor of respondent number 1. It appears that the predecessor in office of respondent number 1 had issued a notice for reassessment relating to assessment years 1960-61 and 1961-62 under section 147 (b) of the Act against petitioner number 1 for reassessing him in respect of the property income from half share of the immovable property in his capacity as legal representative of late Balabhai and in respect of the remaining half share in his capacity as the Karta of his smaller Hindu undivided family. The proceedings for reassessment were the subject matter of appeals up to the Income Tax Appellate Tribunal, and the valuation was ultimately finalized for the whole of the immovable property at rupees 30,600 for determining property income as against rupees 33,600 determined by the predecessor of respondent number 1. The Income Tax Appellate Tribunal has passed the respective orders in June 1969 and January 1970 against petitioner number 1 as the Karta of his smaller Hindu undivided family and as legal representative of late Balabhai. Stop.